1 minute introduction about yourself to the audience here and to the people who are watching this online. And you are one of the. Yes, sir. 10 minutes would be preferable, 10 to 12 minutes. So, you are actually, he's one of the proactive lawyers who are fighting for the concept of shared parenting throughout India. He's based in Punjab and Haryana, practicing in the PNH High Court and also in the Supreme Court. He has authored numerous articles and presentations in India and abroad on this concept of shared parenting, helping us in the Supreme Court also on this issue. So, Shaival, I would request you to please put in your question over there.
Thank you very much. Good evening, everybody.
Yes, sir.
I am speaking online because I am currently attending the 80th conference of the International Law Association at Lisbon. And to put you all in the picture, I am here to talk about the role of international conventions in the development of private international law. Now, very briefly, I am a practitioner with 37 years of standing at the bar, with 9 books and a global family law practice, and I seriously endeavor to propose shared parenting in child custody disputes in the Indian jurisdiction whenever a matrimonial matters, because either in the family court, in the High Court or the Supreme Court, where I frequently appear in child removal cases. Now, to put you in the picture very briefly, the Hindu Minority and Guardianship Act principally says that the natural guardian of a minor child shall be the father and after the mother, and ordinarily the custody of a child less than 5 years of age shall be with the mother. Now, this gender preference and age bar has become a number and a ordinary feature for 2 cases, Lahari Sakharudi and in the case of Kiran Bhaskar. The Supreme Court has demolished the wall of the age bar and of the gender fixation. So, age is just a number and gender is just a feature. The best interest and the welfare of the child is what takes the call. Now, coming on to the secular law under which the petitions are filed for guardianship. As you all know, the Hindu Minority and Guardianship Act does not lead you to a court petition because there is no provision under the Hindu Minority and Guardianship Act under which you can prefer a petition in a court of law. So essentially, you have to file a petition under the HMGA read with the GWA. Now, under the GWA, the petition can be filed where the minor ordinarily resides, and under Section 12, during the pendency of the petition, the court can make such orders as it thinks fit for securing the best interest in the custody of the minor. Now, in my view, this word, such orders for the protection and benefit of the minor, gives complete flexibility to the court to insist upon a shared parenting plan insofar custody is concerned. Now, unfortunately, the shared parenting joint custody is not spelled out in the Hindu Minority and Guardianship Act or the Guardian in Wards Act. Report number 257 of the Law Commission of India by Justice A.P. Shah suggested very, very exhaustive amendments in both these laws and came out with a proposed sharing plan provision and with details of what amendments should be. But 2015 to 2022, nothing has happened and the Law Commission's report gathers dust on these shelves. Now, be that so, where is the window for bringing in shared parenting and joint custody? Now, in our court, there has been an endeavor by the way of making rules for the Family Courts Act. Now, as you all know, the Family Courts Act 1984 is an enactment which empowers the family court to decide a matter relating to custody and guardianship besides other issues relating to marriage. Now, under the Family Courts Act, the family court is empowered in exclusivity of a district court to decide a family court matter, and jurisdiction of children is one of them. Now, under the Family Courts Act, every High Court is free to make rules for governing the procedure of the family court. So, if there is a provision in the Family Courts Act, that will be wonderful. But till Parliament amends the law, the window is in the rules which the High Court can make under the Family Courts Act, in which shared parenting can be a compulsory mandate before the court goes into hearing the matter. This has actually already happened in Mumbai, where the Principal Judge Family Court has already given a mandate that a shared custody, a joint parenting plan must be put forth before the court. Now, why is shared parenting, joint custody a better idea? Now, seeing the flow of the Supreme Court judgment in Vivek Singh and Ramani Singh, wherein parental alienation has been described as a psychiatric disorder as classified by WHO, whenever the child is segregated into the custody of one parent, the child harbors animosity, the child starts feeling isolated, the child starts thinking bad about the other parent, the left behind parent, and becomes alienated and polarized. I have seen this in a number of cases where the child may be perfectly happy and normal. The child goes to visit the father or the mother, but when the child returns to the permanent custody of the mother or the father, the child becomes very hostile, the child becomes very inimical, and the child changes totally. Now, psychologically, this is extremely bad for the development of the child. A child with such mixed feelings can become a very, very disturbed person and will grow up to be a very abnormal individual. In the jurisdiction of the West, shared parenting and joint custody is the rule. There is no way you can talk of singular custody. Singular custody provisions are archaic, are detrimental to the development of the child, and are very hostile to parental care. Now, since India is not a signatory to the Convention on Child Abduction, child removal is not an offence under any law, under the statute in India. But since India has signed the United Nations Convention on the Rights of the Child, therefore India is obliged to make all the provisions of the convention for the best interest of the child as part of the law of the statute in India. So the child's right to inherit personality, a right to a family life, a right of a permanent home, a right of nationality, citizenship, and so on and so forth, has to be incorporated. Now, we had the Juvenile Justice Care and Protection of Children Act, which was enacted in 86, it was amended in 2000. Then, ultimately, the Juvenile Justice Care and Protection of Children Act was amended exhaustively in 2015, and all the provisions of the UNCRC have now been incorporated. Now, Section 2, subsection 9 is the only provision in the Indian statutes which defines the best interest of the child. And in that definition, a very composite, a very exhaustive, and a very meaningful interpretation has been given of what is the best interest of the child. So, if a judge keeps it before him, the best interest of the child, unless there is grave risk, exceptional harm, or very serious domestic violence, there is no way the court can avoid the access of the other parent. So, whenever there is an order granting custody to a parent, let us say because the child is very small or the child is going to went to school, I think a plan should be worked out Monday to Friday. One parent, weekend, other parent, child goes back. There can also be a common way of rearing the child by putting the child in a hostel, by putting the child in a place close to where both the parents live, or in a city where both parents have access. Let us understand that custody disputes are not about the rights of the husband or the wife or the mother or the father. A custody petition is all about the rights of the child. There has to be a child-centered jurisprudence concentrating on the child, the welfare of the child. A child needs a father and a mother. A child is not a table or a chair that the child can be possessed by one parent to the exclusivity of the others. Brainwashing, poisoning, and feeding the child with negative thoughts is self-damaging to the parent who does it. Because one day the child will grow up and the child will walk away with the parent who was not given custody rights. Because the child will know ultimately that this is something which was done to damage him. I have seen cases of where children have grown up with the mother or the father and have walked out one day once they have grown of age because they realize that what was done to them was wrong. So this is the broad scenario of the shared custody and joint parenting. It has not come in the statute book, but it is slowly percolating through the judgments of the Supreme Court, and it is because of child removal from overseas countries that this concept is taking shape. It has not yet formed into a complete enactment, it has not yet formed into a complete law. There are piecemeal steps taken in every court, but wherever at least I get an opportunity, I insist before the judge that I must get access, I must get custody. Now, in a recent matter which I did in the Punjab and Haryana High Court, the child was very happily going on the weekend with the father. But when the child, they talked to the judge in chamber, the child complained that the paternal grandparents were poisoning his mind. So the court said we are not going to allow overnight custody. Now, this was something out of the blue. This was a clear case of parental alienation because of which the child felt unhappy and was saying all these things to please his mother because maybe he felt that if he uses his contact with the mother, then where will he go? So this was, I think, a pressure which was segregated by the feelings. But the father very, very maturely said, all right, I will talk to the child on the phone only. I will not meet the child till the child is comfortable. A child is a very tender mind. A child is a very immature and a very sensitive person. He will do what his parents tell him to do. But sometimes he will say what one parent tells him to do, and that is that. So friends, with this brief introduction, not wanting to take too much of your time, I will take your leave because I have to attend a plenary session in the conference which I have come. And I thank Arijit and the organization which has given me this opportunity. I had to wait, but this is a theme which is very close to my heart. I am dedicated to speak on it, regardless of the constraints of time and the destination I am. So whether I am in Lisbon or whether I am in Toronto, this is a theme I must speak on, and I am very happy to share my thoughts. And I wish the Congress a success. I wish Arijit and his team a hearty pat on the back for the effort they have put in. It is very difficult to organize events like this. So please have a great discussion and formulate principles by which we can come out to logical conclusion. Thank you very much.
Thank you, sir. Thank you, Mr. Malhotra. And we support to the cause. Yeah, we look forward to your support in this issue later on in future. And before we proceed to the next